I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident, that all men are created equal. I have a dream that one day on the red hills of Georgia, the sons of former slaves and the sons of former slave owners will be able to sit down together at the table of brotherhood. I have a dream that one day, even the state of Mississippi, a state sweltering with the heat of injustice, sweltering with the heat of oppression, will be transformed into an oasis of freedom and justice. I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I have a dream today. I have a dream that one day down in Alabama, with its vicious racists, with its governor having his lips dripping with the words of interposition and nullification, one day right there in Alabama, little black boys and black girls will be able to join hands with little white boys and white girls as sisters and brothers. I have a dream today. I have a dream that one day every valley shall be exalted, and every hill and mountain shall be made low. The rough places will be made plain, and the crooked places will be made straight. And the glory of the Lord shall be revealed, and all flesh shall see it together. This is our hope. This is a faith that I go back to the South with. With this faith, we will be able to hew out of the mountain of despair a stone of hope. With this faith, we will be able to transform the jangling discords of our nation into a beautiful symphony of brotherhood. With this faith, we will be able to work together, to pray together, to struggle together, to go to jail together.
A very beautiful morning to you, good people of Nigeria, wonderful people of Southeast, and good people of Anambra State in Onitsha. Wherever you are listening to us from, it's always a pleasure to be here, and you are welcome to Crossfire on Odala 104.7 FM Onitsha. This very beautiful Saturday morning, the 22nd day in the month of November in the year 2025. Remember, on this very program, we speak the truth, we uphold the truth, and we preserve the truth. We call a spade, we can never call a spade by any other name. That's more reason we say, Nos Dicera Veritas, and Nos Dicera Ayudisim Veritas, and Nos Dicera Vivika Kabit Veritas, Nos Dicera Lingolum, and Nos Dicera Contra Lingolum. You are welcome wherever you are listening to us from. Remember, this is a special edition of Crossfire, another hard-hitting edition of our program, where we don't shy away from the tough conversations. Remember, on November 20, 2025, A federal high court in Abuja presided over by Justice James Omotosho convicted Nnamdi Kanu on 7 terrorism-related charges. Allegations that included incitement, issuing stay-at-home orders, and even instructions for bomb making. The court sentenced him to life imprisonment, a ruling that underscores the severity with which the government views his actions. But the story didn't stop at the conviction. Less than 24 hours after his sentencing, Kanu was moved from DSS custody in Abuja to a correctional center in Sokoto State. His lawyer, Aloy Ejimako, confirmed the relocation, raising serious concerns about assets for his legal team, for his family, and for his doctors. And Kanu's family is particularly alarmed. Prince Emmanuel Kanu, his brother, alleges the move may be a veiled attempt to isolate him. His health, they say, is fragile. He's on a special medication under the care of a private physician, and his relocation to Sokoto, far from Abuja, could mean restricted access to the care. Critics have talked. A number of people have said one thing or the other. Nigerians are talking, lawyers are talking, and human rights agencies, they are talking. Everybody's talking. And today on Crossfire, we are going to delve into a number of issues, a number of questions. Why we are where we are, how did we get here, and the future, and what the future lies ahead. Remember, I'm your host, Dr. Tony Olisambeki, the Honorable Speaker, and at the same time the Senior Advocate of the People. And joining me to look at this issue and some other developing issues, I have in the studio a lawyer, a constitutional lawyer for that, and also an advocate of the Supreme Court, a human rights activist, and somebody who is so passionate about law and justice in Nigeria. I have in the studio with me Barrister Moore, and Barrister Moore is not just a constitutional lawyer, he's also a public affairs analyst and also a public affairs commentator who sees things where others see nothing. It's my pleasure to welcome you, Barrister Moore. Good morning, it's good to have you.
Thank you, Dr. Mbeki, and thank you, our listeners, wherever you're listening to us in the world. Thank you and good morning.
In this very discussion, we are going to really raise quite a number of questions. Remember, Nnamdi Kanu was convicted. It was one of the first televised conviction. Nigerians,
Correct.
Nigerians were watching all over the world, and the world was also watching, and everybody saw how it went and how it panned out. Let's begin by asking you what the court, when they say that Nnamdi Kanu failed to put up a defense, hence he was convicted by the court on all counts on the charge sheet, and quite very, very devastating for those who have so much believed in true justice, but some also have their own thought that justice has been served by Justice James Omotosho. Let's get a thought on that.
Thank you. First, I want my listeners to appreciate a point of law, which is called making a defense. In law, not just in the Nigerian legal system, but in every other legal system, an unchallenged and uncontroverted assertion is deemed admitted. When somebody makes an assertion against you, such as a criminal accusation, and you keep quiet, it means you have admitted in the eye of the law. It is called procedural justice. That is why when the prosecution is through with presenting its case, the defendant or the accused person is called upon to make a defense. What is a defense? You have two options. You say you rest your case on the case of the prosecution, you choose to say nothing. Or you call your own witnesses or go into the witness box yourself to contest, to challenge, to discredit, to controvert everything that was said by the prosecution. In the case of a criminal trial like Nnamdi Kanu's own, what is a defense? The moment the case of the prosecution closed and that ruling was given, refusing his no case submission, what he should have done was, one, call his own witnesses to go into the witness box to debunk the case of the prosecution. Two, go into the witness box himself. For some of the things they claimed it was him, and say, no, it is not me. Oh, that is a defense. Then when the prosecution and the defense close their cases, parties are called upon to do what you call a final address. These days we do it in writing. Nnamdi Kanu is not a legal practitioner. I don't know how somebody expects him to write, a legal defense.
But he has a template. Most times, you lawyers use a template, and then all he needed to do is just to get a template and then fixing those things, and then it perfects.
That is the worst irony anybody will look for. A man facing capital offense punishment. It's like going to the hospital for a cancer surgery, and you say because there's a video teaching you how to do cancer treatment, anybody can walk into the hospital and treat himself for cancer. This is a capital offense punishment. You don't ask somebody who's not a legal practitioner to start writing a defense. So anybody who had expected him to write a defense is dreaming. I was at loss the moment they said he had disengaged the lawyers. I knew that problem was coming.
Yeah.
So there is no witness he called to debunk the case of the.
Did he enter into defense in the first instance?
He did not make a defense.
But there was a written address he dropped. And couldn't that serve as a defense?
No. Let's get the stories right. The report in the media was that he went to Court of Appeal and filed some processes to seek judicial interpretation on some issues at the Federal High Court. Now, the proper thing in law, which brings us back to my point, the proper thing in law was that after filing those papers at the Court of Appeal, you certify them. You certified this thing to show that you filed it.
He wanted to arrest the judgment.
And
he wanted to file stay of prosecution. And the Omoto just said there's nothing like stay of prosecution. What we have is stay of execution when judgment must have been rendered, not stay of prosecution. You can't stop the judge or the court from going on.
I'm getting to it.
Okay.
That's why I said he's not a legal practitioner, that the expectation was too much. If you had filed that thing at the Court of Appeal, you certify it. One, then you prepare a motion, exhibit that document as an exhibit attached to the affidavit in support of that motion. Now file it at the Federal High Court. That is how you present documentary proof at the Federal High Court that you have made an application at the Court of Appeal. Then what you ask for at the Federal High Court is not a stay of execution or stay of prosecution. You ask for a stay of proceedings pending hearing and determination of that your application at the Court of Appeal. But Nnamdi Kanu is not a legal practitioner. That is why I keep telling people that the moment his lawyers were disengaged, for whatever reason, I knew
couldn't they have guided him even when they are still disengaged? Because we saw Maxwell Obara and then Aloy Ejimakor still moving around with him. So were they not guiding him while he was doing that?
Well, I'm not part of their team. I think whatever they did was in goodwill.
So did he actually file stay of proceedings, as you said, at the Court of Appeal?
That he didn't file. Whatever he filed at the Court of Appeal was not a stay of proceedings. From the report is that he made an application for interpretation on the propriety of what was going on at the Federal High Court. And based on that, you can get a stay of proceedings. But I've just explained to you the procedure. You certify that document, attach it to a motion and come. Being that he's not a legal practitioner, he didn't have that skill to do it. So when you got to the Federal High Court, the judge will say, there's no application properly before me. And that is what we call procedural justice. So that is the shortcoming that happens when you go to court and disengage your lawyer. Like I tell people a parable anytime they come to my office. I say, doctor, I have headache, give me paracetamol. If you have headache, you know you have headache. You know a doctor treats you for headache. But when you now go to the doctor and say, give me paracetamol, why did you go to the doctor? Cross the road, buy paracetamol and drink.
Oh, okay. I understand that very argument.
It's
that is very important. And I understand that agreement because definitely he's actually facing a serious charge. And then even the matter at the appeal court, he has gone to appeal court. Was that entertained? Was that also admitted?
We can't say. What was the report was that he filed papers. And like I keep saying, he's not a legal practitioner. If you file papers that say High Court Oka and you want to use it in High Court Onitsha. You have to certify the document.
And certifying the document, how does one certify the document?
You do an application for that your document to be certified. You pay the filing fees.
At the court, at the Federal High Court level?
No. At the Court of Appeal where he filed it.
He must certify it.
Yes, that's where he certifies it. Then sits down to prepare a motion.
Okay.
Somebody who's a lawyer, how does he start doing
And I
these
thought that the
things?
motion has its own form. You fill the form and then you get it submitted.
Oh, beautiful. That is a phantom dream. Every motion you sit down and write it.
All right. Now, going further, because we saw how it happened. When one says, I want to arrest the judgment, what does that mean? Because that was what was before the Federal High Court, before Justice Jameson Motacho. He had wanted to arrest the judgment. What does that mean? And why couldn't they arrest the judgment? Because the judgment was not arrested. It was rendered.
Beautiful. How do you arrest a judgment? First, at the High Court level, it's not a magistrate court of summary jurisdiction. Language matters. When you come to court at the High Court level, at the Court of Appeal level, at the Supreme Court level, what is the language you're using? If you don't have good command of the legal language, you will end up saying what you didn't intend to say. In the instant case, there is no provision in the Federal High Court rules to arrest judgment. So there is no provision of the Federal High Court rules on which he will anchor such a prayer. And since the judges are guided by their rules, he will refuse it. Leave sentiments out of it. What the rule provides for is stay of proceedings.
Not arresting the judgment.
Not arresting the judgment. So,
but the proceedings have gone.
The proceedings have not gone.
Because you know what? The judgment day is more like, fixed. The judge has fixed a date for judgment.
All
so
right.
could you have arrested proceedings when a judgment day has been fixed?
Yes.
It's gone?
I've done it before. Not once, not twice. And I got it. How did I do it? Let's leave our parties. It happened here in Anambra. A community was struggling over chieftaincy. And then they did not serve the traditional rule of the community any process in the case. He wasn't even a party in the suit. And almost 3 days to judgment, somebody told him, Igwe, look, they're going to write judgment removing you as Igwe in a suit you don't know anything about. He briefed me. I told him, Igwe, I don't need to go to that court to shout. That what I need from you, sit down, answer these few questions I'll ask, so I can file an application for you to be joined as a party in the suit, that you're the person who is directly affected. Then I also file a second application to stay proceedings pending hearing of your motion for joinder. On the day that application was heard at the High Court of Torture, people had gathered in the community, cooked rice, cooked beans, cooked whatever, bought drinks, killed cow, celebrating that they've dethroned the man. They were eating and dining when the High Court judge sitting at Otuocha heard the application, stayed the proceedings, heard the motion for joinder, joined the Igwe, and said, Igwe, now go and file your defense. We filed the defense. And the matter went to conclusion and he was thrown out.
Right.
So a person affected by such situation, get a lawyer, not doing it yourself.
Right. Now let's move on, because we have seen what actually happened at the Federal High Court, Abuja, and then where Nnamdi Kanu submitted no case submission. It was overruled. And he was shouting to the judge, you don't have what it takes to hear this matter. You cannot hear this matter. The judge said, overruled. At that point, what do you think he could have done? Could he have gone to appeal court to also challenge the ruling of the judge at that level? Because the judge has ruled, you must enter into defense. You have a case to answer. He says, I have no case to answer. He anchored his own submission that the law you are trying me with, they have all been repealed. And we know the position of Section 36 of the 1999 Constitution as amended. Because if you look at Section 36, subsection 8 of the Constitution, no person shall be held guilty of a criminal offense on account of any act or omission that did not constitute an offense at the time it occurred. And this means the law enforced in 2015 is the law that should govern his trial, but they have been repealed by the Repeal Act in 2022 and the Custom and Excise Duty, and also the criminal, the terrorism, and the act was also repealed. So Laws
issues.
are made to be progressive, not retrogressive, and that's why he said he has no case.
Let me answer you on the 2 points.
Right.
And I want to say this and thank Udala Radio for allowing our people to have the kind of audience. Number one, when a judge makes a ruling or a magistrate makes a ruling and you're offended by it or you don't like it, you don't react or respond by shouting at the magistrate or the judge. What you do is you go back, apply for a certified true copy of that ruling, file a notice of appeal, and proceed on appeal to the next level of the hierarchy of courts.
Based on that ruling alone.
Yes.
Even when judgment has not been entered on the
yes,
issue.
Listen up. If he had filed a notice of appeal on that ruling, you use that notice of appeal, file motion to stay proceedings in that high court. And the man will just walk himself into a trap. But the man doing this is not a lawyer.
That
And
could
the
have been
lawyer,
done.
the lawyer will know that that was just their opportunities to stop the trial.
Immediately the
If you did
judge.
that thing, what you do is put notice of appeal 24 hours, certify it, use it to apply for motion for stay, compile your records of appeal, go to the court of appeal. Any day court of appeal give date, you take. And that is the end of the storytelling at the
And the
further
judge, court of appeal, will decide whether he has a case to answer
or not.
he has no case to answer. And even if he's not satisfied with the court of appeal ruling, he can go to the Supreme Court.
Still get another
And the
stay.
Supreme Court can also decide whether he has a case to answer
Thank
or
you.
not. And if they say he has a case, he goes back to that federal
Very
high court.
correct.
That's the way it should have
So
been.
he missed the opportunity, not because he's not a lawyer. This is the point I've been saying, that the day he disengaged his lawyers or the day I said, goodness, we're in trouble.
And then when he was shouting, I have no case to answer, it's not by shouting, according to you. It is by going to appeal court to file.
Yes. And on the issue of shouting, I will also say this for record and history. A man facing death sentence is not a normal person. His emotional control, his emotional level, we should look at it differently. Except you have not faced such challenge in life, you will not understand him. So those who are looking at him shouting in court, those who are looking at him, losing his comportment in court, they should remember that it is a man facing the prospect of a death sentence at that point in time. So some of these human challenges, we should wave them aside and go to the fundamental thing. So people should stop dramatizing that he was shouting in court. And it's even not in his interest, now that a sentence has been imposed, for people to keep talking about it, shouting at the judge. It's not in his interest. You should de-escalate. That is what you do if you want to get him home.
All right, remember, this is Crossfire on Odala 104.7 FM on Niger. And we still have in the studio with us Barrister Moore. And then look at the laws, and Nnamdi Kanu believe that they have been repealed. And those laws couldn't have been used to judge him. He talked about Terrorism Prevention Act of 2013, which was repealed by Terrorism Prevention and Prohibition Act of 2022. And then if you look at it, that was also used. And then if you look at Custom and Excise Management Act, that was also used. And then if you also look at these laws, he said, how can you try me with outdated laws? Laws that do not have life, laws that before recall they are dead, they are buried. What that means that in all of this, it should have been an invalid, unconstitutional, and something liable to be set aside on appeal. But these things were used.
Beautiful. Emotions aside, until set aside by a superior court, judgment stand. Until set aside by a superior court. And I will say this: every judgment has inside it what you will use to sustain it on appeal, what you use to justify it, and inside every judgment is what you use to debunk it, is what you use to set it aside on appeal. All of them are inside that same judgment because it's human rights.
Okay.
And in this case, I'll bring out two. Just two.
All right.
The judge said in his judgment that the sentence takes effect from 20 November 2025.
Oh.
That point alone has finished the judgment. How? If you go and look at the Nigerian criminal laws, when a person is sentenced Go and read any other sentence you see. They take into consideration the period the person was incarcerated. Nnamdi Kalu's story started in 2011 when he started the issue. Now, from arrest, bail, attack on his family residence, he's going out of the country, being brought back again, held in custody throughout the whole trial. That point alone, what you do on appeal is to take a pen and paper, compute the days Nnamdi Kalu had been in detention, the one he was in prison, the one he was in SS custody, the one he was in police custody, over these issues that are now subject of judgments. Add up the days. If you add it up, you will see that he has been in incarceration for close to 10 years. For close to 10 years. Now, when you look at how do you compute time in prison, every 12 hours is equals to 1 day.
Oh, that's how it is calculated.
Yes.
Every 12 hours
is equals to
is
1
just
day.
1 day.
So if Nnamdi Kalu has spent about 8 to 10 years in detention,
Yeah, it means
put together, what does that mean? 3 times 2.
that's about 16.
Thank you. So if you minus it from the 20 years he was given, do you see that the judgment has failed? That he has ended up serving the sentence?
But then
Let me land, Dr.
Okay,
Beck, so
all
the
right.
audience will get me right.
All right.
So what you just do as a lawyer, you do a 2-pronged appeal. The first appeal that says that the man has served the sentence, so because in the same judgment it says the one for 5 years, the one for 7 years will run concurrently.
Yeah.
So since this man has spent a total of about 8 or 10 calendar years in custody before the date of the judgment, that the court erred. Watch the word I used. I didn't say the court was wrong. I said that the court erred to have said it will start on 20 November.
Yeah.
Without taking cognizance of all the days he's been in custody,
Incarceration, exactly.
on incarceration. Please, Court of Appeal, these are the days. Minus it that he has served the sentence.
All right.
So on that note, you apply for him to be released.
But then his life
custody.
imprisonment.
Wait till now, I didn't come.
Okay. All right.
You see, I'm doing it the Nigerian way. So everybody understand us.
Okay.
Life imprisonment, which is the second point, is 21 years imprisonment or 17 years in some countries. So when they say somebody has a life sentence, it doesn't mean you stay in prison and die.
It doesn't mean you will stay there till you die.
No, sir.
Explain more, because many
That
Nigerians,
is why I said,
when
thanks to Dala for this forum.
when the life sentence was pronounced, everybody, and including those who are listening to us, thought that he will stay there till entirety of his life. Can you explain this, please?
Now, when you have that sort of life sentence where a person stays till death, is in case of murder.
Okay.
Okay? But for political issues like
Terrorism.
now, in the terrorism case against Nnamdi Kalu, do you know that throughout the trial, even in the judgment, there is no single individual who was named as a person killed by Nnamdi Kalu?
They said police were killed, military were killed, army were killed, but no individual was named
as a person killed by Nnamdi Kalu.
Okay.
Instead, the judgment said, oh, that he created a situation that caused police and military people to be killed, regrettable as it is. So, can you hold him personally liable for killing them? It is on that, on proving that he's the person who killed those particular people that died, that you will say the life sentence becomes stay in prison till the day you die. But for being an associated person with the incident, after 17 years or after 21 years, you must release him from prison custody. That is the simple truth of it. So if he has spent about 8 to 10 years in custody total, you see he has done the 20 years. What is remaining in his 1 year? In 21 years. So if you put an appeal to get a declaration of the Court of Appeal that for the PD, that point in the judgment saying it should start from 20 November 2025, that is incorrect. That he should take cognizance of all the days he has been in custody, you would have ended up finishing the terms of imprisonment. So that is one point on which you can set aside that judgment and get him out. Second, when you take the prong of debunking the term of imprisonment as having been served, you now take a second appeal which will now be on proving his innocence. So you do a two-pronged appeal on the same judgment. First one, to get him out. When you get him out, you address the issue the family is raising of his being in Sokoto, access to medical care, access to family, access to the lawyers. So this legal team should be proactive in their trying to solve the problem they are faced with, which is you have a client who has a life sentence, he's in Sokoto. You have to travel from Abuja to Sokoto. You will not stay on day 3 while interviewing the client. All right? So they should look at practical options. That's why I said the first point, to debunk the judgment. Now, the second one in the judgment, it says the terms of imprisonment run concurrently. So if you take the time he has already stayed in custody, you see that the judgment for 7 years imprisonment and the judgment for 5 years imprisonment have been served. My brother, why not take that option and get the man out first? Get the man out first instead of complaining of going to Sokoto. The appeal will be held at the Court of Appeal Abuja. Get the man out first. So this approach is a more pragmatic one. Instead of going on social media and escalating the issue, they should sit down and control their temper and do the needful. Let me stop here at this point.
I just as you said, because you said that depending on the offense, and I want us to clear this before we go into some other questions. You said depending on the offense that a life sentence can as well mean 21 years or 20 years, but if it has to do with murder where somebody was killed, it means that person must stay in prison for all the entire part of his natural life. I know, but then some would tell you that the Supreme Court has repeatedly maintained that life imprisonment means imprisonment for the remainder of the convict's natural life, unless reduced by pardon, parole, or commutation by the president or governor, or a specific statutory provision allowing a fixed term in place of life. Can you cite this specific provision or specific statutory provision allowing a fixed term in place of life based on the law we are talking about here?
If you look at that law, without pretenses, the punishment in the law the judge relied upon was a death penalty.
Yes.
So the issue of saying there's a room for 17 years to 12 doesn't arise in that particular law.
But it's because of international concerns that he is going to.
International concern. The law of Nigeria, which the judge pronounced on, says death sentence for the offense alleged. Now, if proved, and the judge said that the offense was proved and the man did not debunk it, and like I said earlier on, unchallenged evidence.
Yeah.
Now, but the judge in the judgment, which I've read, said that I cannot create life. He said, I cannot create life. Because of it, this only discretion I have, I will instead impose a life imprisonment instead of a death sentence. By simply doing that, whether you like or you don't like, Judson Omotosho has given everybody who wants Nnamdi Kanu to go home and stay with his children an opportunity to bring him out without pressure. Because if it was a death sentence that he imposed, by now we'll be running helter-skelter to stop somebody signing an execution warrant. But he said a life imprisonment. My brother, why don't you engage the remaining period you have and get that man to go home? I have seen my colleagues, my friends, my childhood friends whose fathers died when we were children, and I saw the effect on them. Those of us whose fathers lived up to 70, 80 know what it is like. Nnamdi Kanu has children. And anybody talking about this should look at those children. What option do you have to take this man home? Let him go and stay with his children.
What are those options?
Take it. Option number one. Please explore ADR. From the face that I've been saying it.
Alternative dispute resolution method. That's what you're saying. By that is political solution.
I have said this repeatedly. On 21 November, just after that judgment, I listened to other lawyers speak on Channel Television, Arise, AIT, other channels. And none of them was an Igbo man, no. But all of them kept saying the same thing. Why don't you engage the alternative dispute process? And only Igbo people can do that for him. Why is it so hard? And I said, one, a man who has been sentenced to life imprisonment or death does not have the legal capacity to to take certain decisions again for himself. So it is for the family of Nnamdi Kanu, his brothers, his kindred, to call a family meeting. That is the first step. And pass family resolution that as a family, we are going to apply for presidential pardon. We are going to apply for clemency for our brother. As a family, we are going to meet Mr. XYZ.
And then it's not about what he thinks again. It's not about his decisions.
There's nothing to do with his decision. He's incompetent to take that decision. At this stage, you don't tell a man facing death sentence, facing life imprisonment, to be taking such decisions. You're unfair to him.
Even when he's against the decision?
Let him be against it. The law presumes him incompetent. That is why when you accuse people of murder, the law court will say, even if they say they are guilty, court will write not guilty and say prove it. At this stage, Nnamdi Kanu, with respect to him as a person, is not competent to take that decision. The decision should be taken by his family, by his kindred, by the town union of his people, not the state legislature.
Now some people, like if you look at Aloy Ejimakor, who had made a broadcast, and he said that they are going to, appeal court straight away, and he believes that the appeal court will confirm their stance. Let's get a thought about that.
My reaction to the position the council took is a proper step. But I only ask one thing of him. They should de-escalate the media rhetorics. He was on TV saying they'll go on appeal. That is enough. But you don't say you're going on appeal and say the appeal court to see reason with you in public as a legal practitioner. It's not proper. It's not proper. It's like you're bullying the court even before you got there. Then the second counsel was with him also, was giving attention. He said one nice thing, that Igbo people should not go on protests. Let them allow due process. But between the two of them, you saw something that happened on the TV. One talked and almost lost emotional control. The second one talked, turned and back to the press. You don't do that when you're addressing the press. When you address the press, you allow them to talk back to you by asking questions. So there's an emotional challenge for them. And I see reason with them because as a legal practitioner, I've represented my father in court, my brothers, my uncles, myself, my friends. And I realized that the best lawyer you have was a lawyer who was there in the beginning. Once that lawyer can have emotional control, that lawyer can present your case beautifully. So the team of Ejimakor, Ejiofor, Okpara, Mandela, and all that, let them stay. Let them go and do the appeal thing. But they should de-escalate media presence. They should not go to court of appeal, file paper, come out and do media broadcast. It should stop. Then the family of Nnamdi Kanu should hold family meeting. Take a resolution to engage the federal government of Nigeria by writing an application to the President of Nigeria, copy Secretary to the Government of the Federation, copy the National Security Advisor, copy the Attorney General of the Federation, copy the Governor of Abia State, copy the Senator representing him in the Senate, copy the Member of House representing him, copy Abia State House of Assembly, that what the lawyers are doing notwithstanding, they are not saying the lawyers should stop, that they want to open this second process, which is alternative dispute resolution, to get him clemency in the interest of the family, the children. They should stop talking interest of anybody else. Like I said, that anybody talking about Nnamdi Kanu should please go and look at his children.
All right. And then I also want to ask you, because definitely if they go on appeal, and then maybe the lawyers, if they go on appeal, and then the family is going for clemency and pardon, and what if it comes to the table of Mr. President? Mr. President will tell them, you're already on appeal. Why don't we wait till appeal court makes a decision? We now come back to your own application.
Beautiful. Beautiful. I have done it before, both ADR and court process, and got the ADR to work. Where did I do it? When the two get to the table of the president to take the ADR, he's not a fool. Let me tell you how I did it. There was a case I did for two business people in 2010. They bought container load of products from Nigeria Customs on auction. And he had a lady who was doing business in Lagos and an Mbano Prince. After buying their container, paying all the payments they made to Nigeria Customs Service, only for somebody to come and write to the custom that, that is my container, it was stolen, story. The matter went to court. While we were in court, we showed all the papers. It was advertised, they paid the payment through bank. But the lawyers who were coming from Nigeria Customs Service had this beautiful thing they saw in the case. It was a money machine for them. All right? Anytime the case was, they get 3, 4, 500,000 to come to court. So they will quietly leave me. I'll travel from Onitsha to Abuja. They will serve me paper to frustrate me. Later, the matter went to Lagos. I'll travel from Onitsha to Lagos. They serve me paper. This is what they do and kept this matter in court for 15 years. But throughout that 15 years, I kept writing to every Comptroller General of Custom. And only 2 things I will say. Please, these are Igbo people. Don't give the impression that the federal government of Nigeria is being used to rob the Igbo man. That it has happened once. Don't let it happen again under your watch. And this letters, I kept writing it, till it got to Hamid Ali's tenure as Comptroller General of Customs. He took this same stance you just highlighted now. Oh, when you come back from court, I will do whatever the court says. My clients were so angry. I said, please calm down. It is his own position. That one morning he will go, another person will come. And then Bashir Adewale Adeniyi came as Comptroller General of Customs. Now, a Yoruba man who was in customs. I wrote the same letter to him. And the man read it, called for the file, looked at it. And you know what was his reaction? Number 1, he withdrew all the lawyers in customs who were doing the case. Number 2, he appointed a private legal practitioner to come and meet me in court. The private legal practitioner came and met me in court. I said, can't we settle? He said, sure, we can. And at the end of the day, under a space of 3 months, a case that was in court for 15 years, Comptroller General of Customs Nigeria, Bashir Adewale Adeniyi, settled with the Igbo traders, a law from Ihiala, the prince from Mbano, paid them compensation, sacked the 7 lawyers who had been frustrating the case for 15 years. My clients are back in their business with their money in their bank. So if it goes to the president of Asiwaju Bola Ahmed Tinubu, it is the presentation with which it came that will produce. And
apart from that, Mr. President has been following the case. There's no doubt he knows everything, and he also wants to know what the family thinks, and he also wants to know what about the stakeholders from Southeast thinks, and he wants to know what so many people think, the political leaders, what they think.
No, Dr. Mbeke, I take exception to think what Southeast political leaders think.
Don't you think he's a politician?
No,
Mr.
sir.
President is a politician.
No, sir.
So he may also draw their input.
No, he doesn't need it.
He doesn't need it, but he may need it. Based on the fact that he's a politician.
No, sir. In modern international engagement, China has taken center stage many times because they appreciated a point called multilateralism. Don't look at things from a one-way point. Asiwaju Bola Ahmed Tinubu will make history by letting Nnamdi Kanu go home to his family. Asiwaju Bola Ahmed Tinubu will return Igbos to a feeling of belongingness in Nigeria by letting Nnamdi Kanu go home. There are people in Igbo land whose source of living for the last 10-15 years is the Nnamdi Kanu crisis.
I think
stop it.
All right, I'm gonna ask you a question, but that will be when we come back. You're gonna respond, because the next question I want to ask you, because we are trying to preempt a lot of things. Why didn't Buhari release Nnamdi Kanu? All these why Igbo leaders, governors, they met him. He simply told them that the case is in court. They asked Buhari, why don't you use your power under the constitution to file noli prosequi by ordering your attorney general to file noli prosequi to withdraw the matter? But he said it is in the court, and Buhari left the scene, and then Tinubu came on. There had been meetings. In fact, sometimes the governor of Abia State, LXOT, promised us that there had been a lot of things happening behind the scene. But we didn't see much until the convention we saw on 20th of November. And then we also saw a situation where the governor of Anambra State has also met the president and asked Mr. President, release him to me on bail or put their conditions. because they have always told us, talks going on, but we
You
saw
have seen the talks failed.
the conviction.
Sure,
But I'm going to
sure.
ask you with this question. You're going to respond when we come back from the break. One, why didn't Buhari release him? Secondly, it is over 2 years President Tinubu is in power. Why hasn't he listened to all the pleas that have been coming through? And thirdly, can you also say that Nnamdi Kanu is an Igbo phenomenon or an Igbo political phenomenon
Thank you.
in modern Igbo history? Who is the man Nnamdi Kanu that is also known as Mazi Nnamdi Kanu? Let's go for break. When we come back from the break, you are going to respond to these issues. Remember, it is Crossfire on the dollar
You're welcome, Dr.
104.7.
Vic. You're welcome. You're welcome.
Udala Radio, 104.7 FM.
When the city sleeps, the river remembers. When the drums call, Onitsha awakens. This December, the call grows louder as Udala Radio joins forces with the Golibe Festival 2025. From December 26th to New Year's Day, the heartbeat of the East comes alive. Music, laughter, art, culture, and the unstoppable joy of homecoming. This year promises more energy, more color, more connection. A festival for every proud son and daughter of Igbo land. Stay tuned to Udala Radio, your front row seat to the celebration that never fades. Golibe Festival 2025. Exclusive media support by Udala Radio. It's not just a festival, it's who we are.
Udala Radio, 104.7 FM.
Yeah, welcome back. It's still Crossfire on Udala 104.7 FM. This very lovely, beautiful Saturday morning. Remember, today still remain the 22nd day in the month of November, the year 2025. We are still in the studio with Barrister Moore, our guest, this very morning. Let's go back to some of the questions we asked. Remember, you can be part of this very program by going straight to our social media handle. Join us on Facebook, on TikTok, on Twitter, on Instagram, and also on X. All you need to do is to search Udala FM. Remember to join us if you want to watch this program on YouTube. Search Udala FM Crossfire, and also go straight to Facebook, search Udala FM, and be part of this program. Let's come back to Barrister Moore. The questions I asked you, about 3 or 4 of those questions. I don't know if you get those questions.
I got them
All right, let's quickly
I
go
got
on.
them down.
All right.
Number one, on the question of why did the Buhari regime not release Nnamdi Kanu, I have only 2 answers. A, all the people who approached the Buhari regime for the release of Nnamdi Kanu did so in what you call misstep. There was political misstep in the manner of approach they used. Number 2, throughout the Buhari era, there were people whose source of political stability felt threatened by the Nnamdi Kanu phenomenon. So whenever you went to the Buhari regime to say, let this man go, leave this thing, those people go and say, no. We can't manage the crisis that will be the fallout of it. So there was misstep in approaching the Buhari regime. So what the Buhari regime did was to just hide under legalese. Please, when you finish in court, let us do what the court said. Just like I explained what happened in my own client's case. Then we'll go to the second issue. Why we had 2 years now of President Ahmed Bola Tinubu he has not released Nnamdi Kanu until 20th November judgment. Go and check all the representations that have gone to Nnamdi on behalf of Nnamdi Kanu to the Buhari regime, to the Bola Ahmed Tinubu regime. I stand to be corrected. You will not find one letter from his family asking for that pardon. You will not find it. Because if it existed by now, somebody would have thrown it out on social media. Then number 3, on the issue of filing nolle prosequi. As a lawyer, I know that you don't get nolle prosequi by word of mouth. So, Governor of Anambra State, Governor of Abia State, Governor of Imo State, Governor of Enugu State, Governor of Ebonyi State, together going orally to ask President Bola Ahmed Tinubu to direct the Attorney General of the Federation to file a nolle prosecution in the prosecution in the matter is also a bilateral misstep. The Attorney General of the Federation cannot be approached in that manner to file a nolle. A nolle prosequi means I am not interested in the prosecution. It doesn't mean the man is not guilty. But it is a power the Attorney General has to use to stop abuse of court process or intimidation in the use of court process. The way to invoke that nolle was for the legal prosecution team of Nnamdi Kanu to prepare an application for nolle and plead the case of their client in it and serve it on the Attorney General. That was the proper thing to do, which I said again, I stand to be corrected, it was not done. The legal team did not apply for nolle, the family did not apply for nolle, the town union did not apply for nolle, Ohaneze Ndigbo did not apply for nolle. All the political bigwigs talking today, none of them applied to the Attorney General of Federation for a nolle prosequi to be entered in that
Remember
case.
when Buhari visited Ebonyi State, Dave Umahi with Ohaneze Ndigbo made a passionate plea
Orally.
before the president released our
Orally.
brother. And he
Orally.
said that the matter is in court.
That's why I said earlier
They
on,
made oral application. You are saying
Yes.
they did not make a written application.
Yes, you cannot get an Attorney General to exercise that power by oral requests.
It couldn't have been oral request.
It cannot be.
It's not about having a
people should
conclave
learn.
meeting with the president.
No, sir.
They must have prepared something
In writing.
and
Address
serve
to the
it
Attorney
as
General.
general, and also meet Mr. President to
Uh-huh.
act on it.
Thank you.
You
That
think
is
that's the
proper
best way
thing.
to go?
That is the proper and the only way. I wrote letters for 15 years. Despite a prosecution was going on, despite a litigation was going on, the judge that even did this matter of my clients I'm talking about was a Yoruba judge.
Because
all
of
the
time.
objections he
Because
took
of
out.
time, we have to move fast.
Uh-huh.
Let's
So-
go straight to the second question.
Yes, on whether he is a phenomenon or an Igbo icon. You see, when you put people in the position that the Kanu has put, you end up inadvertently making them icon in the eyes of their people. So, as of today, by sentencing Nnamdi Kanu to 20-year life imprisonment, a 20-year term, a 5-year term to run concurrently, now moving him to Sokoto, and people are doing all the social media thing about it, indirectly, you are turning him into a cause celebre. But as I said, please, whoever is involved in this social media hype of his going to Sokoto, or the judge should de-escalate in the interest of the family.
All right. I remember you did say that even if he had been, or even if he were judged by a repealed law, there could be something in that judgment that could either sustain it or debunk it. That
Yes.
was what he said.
Yes.
But I had wanted you to say outrightly, was it right to have used a repealed law to try him?
No, you see, I've read the judgment. And the judgment stands on its own. Anybody who's offended by that judgment.
So you are saying
go
that
on appeal.
or so you are saying that
Not
you
on
can't say
social
whether it
media.
is right
I
or
will never
wrong
say it.
until appeal is initiated.
Yes.
All right. Let's also
Yes.
look at what
We should show restraint.
I just come in contact with what one of the Nnamdi Kanu's lawyer, I think those that started this very case, Ifeanyi Ejiofor.
Good. He was there in the beginning.
He was there in the beginning. He made a statement. In fact, he just posted it about 23 minutes ago. And in that very statement, he used bitter and unparliamentary, uncomplimentary words against those lawyers that managed Nnamdi Kanu's case. In fact, the title of his epistle is Nnamdi Kanu's Avoidable Ordeal: How Amateur Legal Showmen led a high-profile case into a judicial ambush. And then it went on to say, when justice became a performance, the tragic consequence of turning Nnamdi Kanu's trial into a content, that the lawyers were busy making content out of the trial, but they were not just there. I'm going to just take an excerpt of what he said. In fact, he said during the period our team, I'm quoting him now, during the period our team handled this matter from 2015 to December 2024, up until Professor Mike Ozokome, SAN, assumed leadership of the legal team in 2022. We were on the threshold of securing yet another major relief for Mazi Nnamdi Kanu, particularly after the Court of Appeal discharged and acquitted him in 2022. We sustained pressure, strategic diplomacy, and airtight legal maneuvering, which placed us on the verge of another monumental breakthrough. But regrettably, certain sensitive details of this progress were perhaps innocently disclosed by Mazi Nnamdi Kanu to some of these clueless clowns. He's calling his fellow lawyers clueless clowns. Rather than support a strategy that they barely understood, they seized the information as an opportunity to derail the entire process and treacherously orchestrated a change in the status quo. Consequently, we exited the team gloriously and with our integrity intact. He said quite a number of things. And then one more thing I want to say before you come in to react to some of these things Ejiofor was actually writing. He said, the unthinkable happened. A trial that could have been paused or avoided ab initio had the proper methodology and engagement been applied, a conviction that could have been prevented, an outcome that was entirely avoidable, yet allowed to proceed under the guidance of legal lightweights, intoxicated by social media relevance. He went on to say, even when the judge said that self-representation is so dangerous that instead of these amateur and clueless lawyers, according to him, I'm quoting him, to see the advice of the judge, but they were clapping for Nnamdi Kanu when he said he was going to defend himself, and they applauded him. If they were true consultants who were meant to consult with integrity despite the consequence, that they couldn't have clapped for him when he said he was going to defend himself, even when he was warned by the judge. And then he went on to list a number of lawyers that were at one point engaged or the other. He said, how did famous legal minds, globally respected senior advocates of Nigeria such as Chief Kanu Agabi, SAN, Chief Onyechi Mazo, SAN, Michael Zekeme, SAN, other erudite members of the INABA, men fully versed in the anatomy of high-wire criminal litigation, become disengaged at the most critical moment of the trial, only for mediocre adventurers to hijack a matter of international significance and reduce it to a TikTok Lego carnival. The person making this statement is Sir Ifeanyi Ejiofor, who is making this very statement. Let's get your reaction. Is he really angry because he was disengaged, or because there was a time he was accused of sabotage? He was accused of using the case to derail Mazi Nnamdi Kanu, that he became so popular even more than the person being accused. So at this point, Nnamdi Kanu disengaged him. He said he was disengaged in 2004 until this, according to him, amateur lawyers took over. But he didn't call anybody name, but we know the people he was referring to. Let's get your thoughts.
My thought is that one, I'll first plead with all those he called their names in the write-up and all those insinuated to refer to in the write-up to consider that the same thing I've been saying is what he's saying indirectly, which is that the misuse of social media was actually part of what ruined the representation. But on the heels of that, I plead with all of them, all those he has called their names, lampooned them, insulted them, offended them with this write-up, they should please and please de-escalate by not responding. The internet never forgets. They should not respond. They should allow the wind to blow. The Japanese have a saying that when one typhoon blows, another remains silent. Let them pretend they didn't see this, in the interest of seeing that the family can explore AGR The legal team remaining can try the appeal, whichever one is the objective of bringing the man home to go and stay with his children. Second, on the discourteous language of calling your fellow legal practitioners lightweight, mediocre, all those things are signs of loss of emotional control. And as a legal practitioner, he knows that using such language, publishing it, amounts to libel. But there's something that is called dog baiting. When you want to kill a dog, you bait the dog to come out. So the legal team that he's baiting by this write-up should not fall for it. They should go and face the appeal they want to prosecute, not responding on social media. Like I said earlier on, they should de-escalate.
He was accusing them of social media, stunts, but he's also on
But
social media.
if they go on social media to respond to him, then they are guilty.
But when he was also, in this case, he was also on social media.
Let him enjoy the drama.
He was also making the content.
Yes, sir.
But he's
But let him-
now accusing these people of
doing the same thing.
thing.
That's why I said they should keep quiet and focus on their appeal. That this is a dog bait. It's called a dog baiting. So when it happens, then the issue of whether he was angry because he was relieved of the brief, he should remember also that the same way Nnamdi Kanu debriefed him was the same way Nnamdi Kanu debriefed every other lawyer,
Not just him.
including these people he's lampooning now.
These people, turned to consultants. They were not his lawyers again.
Again,
They became
debriefed him.
consultants.
He debriefed him the same way he debriefed other lawyers,
Everybody.
and even this last team. And despite the advice of the judge, which was in public domain, and like I said, a man facing a death penalty
May not really be himself.
may not really be himself. So some of these things we should please take it in context.
And he shouldn't be lampooning these people, because he said
He's
that
free.
when Nnamdi Kanu wanted to self-defend himself, they should have been against it.
No, sir, you don't force clients to take your advice.
They should have been. That's what he was trying to say. They
You
should
don't
have been
force a
against
client to take your
that. They were
advice.
clapping for him for whatever
No, sir.
he chooses to do.
If he said they were clapping, please, I apply for the records of the proceedings to see if the court recorded those lawyers as clapping. If the court has no record of them clapping, then ignore the comment. Ignore it. If the trial record of proceedings did not show Ejimako,
Maxwell,
Okpara, and the other young people with them clapping in court, if that is not in the record of proceedings, you should ignore it.
And remember, that case made him popular, made a Ejiofor popular. Nobody
Yes.
knew Ejiofor from anywhere. No, but that's true. That case made him popular.
Well, so be it.
But that's
So
the way
be
it is.
So
Now let's quickly go on, because we've seen arguments and counter arguments. But I want to also say that, just like we said, can you summarize to our listeners? They listen on the social, political issues in Igbo land that gave life to Nnamdi Kanu phenomenon, now encapsulated as a life imprisonment jail time. What really gave
one thing.
him that kind of life as we have it currently?
Victim of a social phenomenon.
A victim of social
That's
phenomenon.
what he is. The fundamental fact of what brought about Nnamdi Kanu becoming a voice of an agitation that has been mismanaged, and today he's now a victim of that agitation, is what I keep saying all the time: the perceived marginalization of the Igbo man as against the real marginalization of the Igbo man. There is a perceived marginalization of the Igbo man. Then there's a real marginalization of the Igbo man. The perceived marginalization of the Igbo man is that Igbo people don't get made senior advocates. They don't get made judges. They don't get made minister. They don't become chairman of boards and parastatals of the federal government of Nigeria. That is the perceived marginalization. What is the real marginalization? The real marginalization is that when you write the name of an Igbo man to be made a federal judge, his fellow Igbo people will write petition against him or her. When you write the name of an Igbo man to be made a minister, his same Igbo brothers and sisters will write petition to stop it. When you write the name of an Igbo man to be made the chairman of a federal parastatal, the town union president will go and write petition to stop it, and now come back to say Ndi Igbo are being marginalized. Who really is marginalizing the Igbo man? I have keep saying this all the time, that the Igbo man should go and ask himself who is his real enemy. Nnamdi Kanu is a young man who, to all intents and purposes, did not bear arms during the genocide that happened in Igbo land. So he does not know what a war looks like. My father fought to defend his homeland. And I asked my father, what is it like? He said, please, my son, don't let it happen again. So for a young man who did not participate as holding arms in defense of his homeland to be calling for war is emotional immaturity. Now this has translated into other youths seeing him as a voice speaking truth to power on the marginalization of the Igbo man. But that word he was using, the words he was using, were they appropriate in a multilateral context of a multi-ethnic society like Nigeria? It is bound to be misunderstood. It has now been misunderstood, and Nnamdi Kanu has become the victim.
All right, now post Nnamdi Kanu's life sentence. What are the takeaway lessons for the issue or the question of Igbo marginalization in Nigeria?
Number one takeaway lesson for Ndi Igbo is to please go back to their drawing board and ask themselves, how did they mismanage the Igbo question, the Igbo issue, to the point that an Igbo man is now facing life sentence for talking about Ndi Igbo? Number two, they should ask themselves, all these people who are imposed leaders, imposed self-appointed spokespeople of Ndi Igbo in diaspora, who have access to foreign governments that they talk to, they should please talk to the people here before they go to talk to those foreign governments, so that these misunderstandings that have now in effect brought about somebody facing life sentence will not repeat itself. Then finally, that the Igbo political groups should go back to their drawing board, because a fallout of Nnamdi Kanu's sentence will be political anger against the existing political structure in Igbo land.
Okay, and then before we open the phone lines, I know many people have been calling. They want to share their thoughts. Remember, this is Crossfire on Udala 104.7 FM. I'm still your honorable speaker, Tonio Lisambeki. And I'm here in the studio with Barrister Omo, and we're looking into what transpired on Thursday at the Federal High Court, where Nnamdi Kanu was given life sentence. But before then, I want to ask, it's important because I've seen this turn to tribal and ethnic thing. It seems that those who are over there, they are mocking, not just mocking, trying to make mockery of Nnamdi Kanu's predicament. You know, some of them have started calling him the king of the Jews. They have started telling him, "Oh hell, the king of the Jews. Oh hell, the leader of IPOB. Oh hell, the leader of the prison inmates in Sokoto prison." I've seen all manner of mockery going on, but that's by the way. And then also maybe want to find out from you, because we know very well, can there be any light at the end of the tunnel, the way things are going? We have looked at the whole thing. The appeal coming very soon. Is there anything that's going to come out of appeal? You have told us, you've advised ADR and an appeal. You've said it clearly here. That's the way it's going to work. And you also say that the family, as a matter of fact, should also apply for clemency. They should do that on their own, not by any push or not by anybody. Any stakeholder should be doing their own thing. If you know that which you want to do, be doing it on your own. Don't say this, don't say that. The lawyers should be doing their own, the family should be doing their own. The Ohanes and Igbo, they should be doing their own. It's not about sustaining the pressure. But some people have said that Mr. President may not even release him until he must have served for more 10 years or more 8 years. That they have not seen somebody who is sentenced immediately, then he's also released immediately, the person is sentenced. That sometimes if somebody is sentenced, if you come for clemency, you be asked, allow him to stay in the prison for 3, 4, 5 years more, so that it will water down the sentence, so that you can make good of that.
That is why I said, take the legal loophole in the judgment. Compute the number of days he has been in custody. That is complete legal justification for clemency for him to be released before.
Oh, you can use loopholes in the judgment.
Use it.
So fight for clemency.
Use it.
But let me also ask, the ways in the streets are that this man was not caught with arm. He was not caught with cutlass. If you look at DSS report, they say that they saw a laptop, they saw bag, they didn't see any harm object. But look at terrorists working with arms, being negotiated with by the government, being in the same confined space with the government, talking about negotiation with their arms, real terrorists walking freely in our streets, on our roads. But this man was caught with nothing, but he is facing life sentence. The first question: are we having a double standard judicial system or social judicial system? And probably secondly, people are saying it's because he is an Igbo man that this wouldn't have happened to a northerner, to a southwesterner. That why it happened to him is because as an Igbo man. Is it the case? I want to find out from you.
It is not the case.
Before the last question,
It's not the case. What happened, like I keep saying, is inability to manage multilateralism. In the case of Nnamdi Kanu, whatever is the accusation, whatever the story, there's a judgment. And I still go back to it. His inability to handle multilateralism. His case presentation was good. Midstream, they stopped and it collapsed. So having collapsed, what you do is you salvage what is left.
so damage control all this.
So don't talk about whether they saw him with laptop. Don't talk about whether they saw him with a phone. Don't talk about whether he was doing broadcast from Ant Hill to anywhere. Just look for that loophole I've pointed out to
and if you look at some of these loopholes, the issue of territorial jurisdiction, because
Yes.
he said that he made the broadcast and it was heard. That was the effect,
So
but
where
not
did
the
he
action.
Where did he make the broadcast
Where
from?
did he make the broadcast from?
Those are
He
things
did-
he articulates in their clemency.
And at the same time, some of the things the judge relied upon to sentencing, the judge said you order the killing of the police, you order the killing of the army, you say that Lagos will be inflamed during the NSAS, you say that go out there, anybody you see, this and that, but they could not link anybody killed with evidence to him. So
That is
that
the
people are
point.
saying, what kind of judgment is that? That they had thought that before you pass judgment that somebody said something, it must have seemed to have happened with the evidence. Also link back to that statement. These things were not seen, just broadcast, and they did not also put the broadcast in context. They copied the area he was saying this, and that. They didn't also say where he was saying that if they attack you, do this, because his statements were more like if they come to attack you, do this, and where he was saying cut off their heads, but they picked where he said cut off their heads without also saying what they could do before he asked them to do that in self-defense. That they say that some of his statements were in self-defense, not naturally to go out,
Inciting.
but
Not inside.
these things we are not really present before the courts.
That is where the issue of defense arose. It was in his defense he would have done what Trump is now doing to BBC. Play the full video. You didn't do that defense.
You didn't play the full script.
So if he had entered the defense, you just put application, play the whole video, and those things would have collapsed.
Play the whole voice, not cut it where
Nothing
you.
would have debunked itself. But he didn't do that. That's why I keep saying, please, there's a judgment. Let's look for way out on it. Use it. Leave what has passed. It has passed.
It has
The
passed.
water has flowed.
No
by.
lamentations again.
No
Leave the lamentation.
leave
Way
it.
out now.
It's just all I'm going for. And what is the way out? Like I said, that in every judgment is the ground to sustain it, the ground to debunk it. Take point one. Anybody who's saying the president to stay, Allah says he should stay 10 years or 4 years. Have you started practicing witchcraft? I knew.
All right, let's
That is
quickly,
my answer to that person.
all right, let's quickly take a moment to go for break. When we come back, we open the phone
Thank you,
lines
thank
and then
you.
also read your comments. We have about 30 minutes more, and we're gonna use that 30 minutes to entertain your calls, to entertain your statements, and also ask our guest question who he is in the studio, who has done justice to all the questions we have raised for him this very morning. Remember, this is Crossfire on Udala 104.7 FM on Nature, the most listened political show here in the Southeast, and I can dare to say in Nigeria.
Udala Radio, 104.7 FM.
When the city sleeps, the river remembers. When the drums call, Onitsha awakens. This December, the call grows louder as Udala Radio joins forces with the Golibe Festival 2025. From December 2016 New Year's Day, the heartbeat of the East comes alive. Music, laughter, art, culture, and the unstoppable joy of homecoming. This year promises more energy, more color, more connection. A festival for every proud son and daughter of Igbo land. Stay tuned to Odala Radio, your front row seat to the celebration that never fades. Golibe Festival 2025. Exclusive media support by Odala Radio. It's not just a festival, it's who we are. When you think of roofing, think of strength. When you think of durability, think of beauty. And when you think of all three combined, think Best Aluminium MFG Limited. At Best Aluminium, we don't just manufacture roofing sheets. We create protection, comfort, and style for your home and business. Whether you're building from scratch or repairing an old roof, we have exactly what you need. Our products include stone-coated roofing sheets, aluminum roofing sheets, and colored roofing sheets. But that's not all. We also offer residential and commercial roofing services, roof repairs, gutters, emergency roofing services, and even durable cookwares that bring quality to your kitchen. Visit us today at 30/32 Anyika Street, Awada Obosi, Anambra State, or call us right now on 0806-416-2374 or 0706-059-6203. With Best Aluminium, you're investing in peace of mind, in beauty, and in the future of your home. Because when it comes to roofing, the best choice is always Best Aluminium MFG Limited. Tomorrow's technology today.
Quality bread, Wendy's bread, for your family breakfast. Wendy's bread, Wendy's bread, Mama, Papa, they like Wendy's bread, Wendy's bread, even children, they like Wendy's bread, Wendy's bread, and in town, Wendy's bread, you get it better, tasty, we go sweet your belly. Wendy's bread, Wendy's your bachama. Wendy's bread,
Wendy's bread, tasty bread. You can contact us on our official address, Second Business Park, Enugu Road, GRA, beside Onisha, Anambra State. We also have another branch at St. Michael Plaza at Tandy Road. Also contact us on 070-1149-1571. Wendy's bread, your tasty bread.
Wendy's bread.
Biko genti n'ọkwa dị oke mkpa iji ohere eme ka ọhaneze mata karịsịa ndị na-achọ ịzụ ụlọ ahịa na ndị na-azụ ahịa n'ahịa New Auto Spare Parts Mkpọ New Parts dị n'okpuru ọchịchị Idemili North. Mbọ ụfọdụ ndị na-agba ịghọgbu ndị mmadụ ịzụrụ ụlọ ahịa n'ụzọ iwu na-akwadoghị n'elu ụlọ ahịa alụrụ ọhụrụ n'ime ahịa ahụ. A na-adụ ọhaneze ọdụ ka ha zere onye ọbụla itinye ha n'ọnwụnwa site n'iresi ha elu ụlọ ahịa ahụ dịka ụlọ ikpe mkpegharị na-etinye ọnụ n'okwu ahụ. Emekwara ka amara na ọ bụ ndị nwe anụ ụlọ ahịa ahụ nwekwa elu ya. Ọzọkwa onye isi oche Idemili North enyekwa onye ọbụla nkwado ike ụlọ ahịa ọbụla n'elu ụlọ ahịa ahụ dị na New Parts. Ya mere kpachapụ anya maka ego gị dana na mmiri. Asịkwana na agwaghị gị agwa maka na ụkpana okpoko gburu bụ ntị chiri ya. Ndị binyere aka n'ọkwa bụ ndị landlord stroke shop allottees na BOT chairman New Auto Spare Parts Mkpọ bụ Chief Paulson Emera.
When the stakes are high, the debates get hotter. When the issues demand clarity, we bring the fire. Welcome to Crossfire. Crossfire, where politics meets perspective, where issues are dissected, and where no topic is off limits. From the corridors of power to the pulse of the streets, we break down the politics, the controversies, and the decisions that shape our nation. Join Dr. Tony Olisangbeki as he puts guests on the hot seat, drilling them with the tough questions, demanding the hard truths, and leaving no room for half measures. Get ready for fearless conversations and uncompromising analysis. Crossfire, exclusive on Odala 104.7 FM Onitsha, every Saturday from 9 a.m.
You're welcome back. It's still Crossfire on Odala 104.7 FM on Nature. This very beautiful Saturday morning. We've been talking about the conviction of Mazi Nnamdi Kanu, everything that happened there, how the journey began, how it happened, and what went wrong, and where we are, and the way forward. We have talked about all this, and then we have our guest who has done justice to that, Barrister Christopher Moore, who has done justice to that. Let's quickly open the phone lines and allow it to come in. We are going to allocate just a minute to everyone that comes in, because we know that so many people, plethora of people that would want to say one thing or the other. We may not give you that very space to say everything you want to say because of time constraint. Let's go straight to the phone lines. Let's quickly let you know you can call 0803 221 6973. You can also call 0803 827 6694. I'm still here, Honorable Speaker Tony Olisa Mbeki. Let's go straight to the phone lines and get your thoughts on some of these issues. Good morning, you are welcome. It's good to have you. Good morning, you're welcome. Oh, we seem not to hear from you, but both of you are talking. Okay, let's quickly do this and then see how it goes. Hello, good morning. I guess you guys are on, but then we cannot. Hello. We have to pause for a moment and think it's one of the technical errors. We have to fix this thing because I know but all of you are talking, but then it seems that it's not coming out here, and possibly our engineers will just look at the whole situation and know why it's so. You are talking, but it cannot come out here. Let's quickly, while they try to fix that, and let's come back to Barrister Christopher Moore. We have seen the battle. More like people will define what had or what has happened and what we've seen so far. As the season, I would say, I've seen, I've come, and I've conquered. You know how it's been said, Veni, Vedi, All right, I think it's on now. Somebody actually. All right. It's on now. Okay, we can now hear. Sorry about those who have called earlier, but they couldn't get through. Good morning.
Thank you.
Hello.
Good morning, you're welcome.
Hello.
You are on. What's the name and where you calling from?
Good morning.
Good morning.
Are you hearing me?
And we can hear you, please go on. What's your name and where you calling from? All right, we may need to let you leave because of time. Good morning, you're welcome. It's good to have you.
Good morning, Chief Dr. Tony Olisambeki.
You're welcome. Let's quickly do this.
Good morning, our guest in the studio.
Thank you and good morning.
My name is Ogochukwu, all the way from Udielu State.
You're welcome, Ogochukwu.
What I want to say here is very simple. Sentiment aside, this judgment that happened on Thursday has been perfected. The part that B has vowed to tell Mazi Nnamdi Kanu. How can you try somebody with a repair law, 2013 law as amended? Yeah? It's uncalled for. And I want to ask my barrister here.
I'm listening. Go on. Ask
Hello?
your question.
Go on with your question.
Nnamdi Kanu, Supreme Court has admitted that Mazi Nnamdi Kanu, the way and manner they used to bring him back to Nigeria is unlawful. And Tony, we agree with you that in every case, process matters a lot. If the process is faulty, the court will modify everything. Why Supreme Court to refer the case back to Federal High Court?
That is a very good question. Why did it? But we're going to come back to that. Thank you so much.
Question is not.
All right, your question is noted because of time. We have to manage time. Good morning. You're welcome. It's good to have you. You're welcome.
Thank you very much, the last caller. The barrister is just designing this thing as if they don't know what they did. So plaster here, they remove this block, do this to plaster here just to block something. When they have perfected, as in they have finalized this thing even before that yesterday. Somebody was convicted only yesterday and he was thrown to Sokoto immediately. And you're telling me that they have not done this already. There is nothing anybody wants to tell me. I cannot be that gullible enough to be defeated as if the federal government didn't know what they just perfected what they did yesterday. It is already on the pipeline. what they want to bring out. So going to appeal, starting that they still have in mind, we still stand unless the international body came to our rescue. And I want to tell the Nigerian government, they must know, and also Igbos, because there are some Igbos that they are supporting this. Whether you like it or not, you support Nnamdi Kanu or not, this is a conviction of Igbo man. In politics.
All right. Thank you so much. We have to let you go. Good morning. Good morning. You're welcome. It's good to have you. Sorry about that. Good morning. Okay. Good morning. You're welcome. It's good to have you.
Good morning.
You're welcome. It's good to have you.
Please go on. Ask me a question.
Please go on. What's the name and where you calling from? Because of time.
My name is Solomon.
Solomon, please go on.
I call it from Ugwagwa.
Please go on with a question.
I'll help the barrister where all of us do. The barrister talk to. If anything will happen for Batman, they can is a political issue. It's our Igbo leader, Igbo constituency, not them with the problem about Batman. So if they lose anything concerned about Batman, they can who don't know where he goes tomorrow or next tomorrow. So may God bless that barrister. Talk truth about what happens about Batman. So may God bless man.
All right, thank you. All right, thank you so much. Thank you so much. We have comments coming from different places. Good morning, you're welcome. It's good to have you. All right, take it easy. We are just taking your calls after the order, one after the other. Good morning. Good morning.
Good morning, Dr.
You're welcome. It's good to have you.
Yeah, my regards to the barrister.
Thank you, and my regards also to you.
Joining you from home.
You're welcome.
Yes, that judgment, we continue to discuss it line by line. And people just have to look beyond Nnamdi Kanu as a person because of what he represents. Just like what we believe in. It's what other people believe in Igbo land. What he's pursuing and also what he represents. A particular interest of Igbo people. When we talk of the larger number of the people, because I know that some people are against the ideology of Nnamdi Kanu. But the majority of Igbo people is what we are focusing on. Somebody can renounce his faith. Nobody can renounce your faith. But it is you who can stand up and renounce your faith. So what Nnamdi is holding is a faith, which he cannot renounce even by himself because he represents the interests of the people. And that is why we must be very careful about this case. That judgment as we see it, just as some people have opinion that they have planned it, this is where it concerns Igbo people because anytime it is Igbo man, people will become so meticulous and so very holding up to a particular point that Igbo must suffer over extra mile.
All right, thank you so much. We have to let you go. We can also take comments from Facebook because if you can't come here, please go to Facebook and drop your comments. We can still take them. All right, we have this one that says Mr. Tony or Mazinwore Chikwadorum Osinachi says, Mr. Tony, I appreciate every bit of the lawyer's analysis this very morning. He's really awesome. Not like the type. Oh, sorry. I'm not going to just talk about that one because I don't know. Maybe if a lawyer had come yesterday or not. He said, not the, maybe one that came yesterday. No. All right. That's by the way. We have this one, Master Obe XJP. Good morning, Speaker. I advise Igbo people who are knowledgeable in law to come together in handling this matter. If, for example, the lawyer in the studio could also be involved, for Nnamdi Kanu to be awarded a life sentence is out of ignorance from the agitator status, and all Southeast captain of industry and Southeast governors failed in Nnamdi Kanu for not supporting him in legal battle. Even your son killed human being and all that. I think you said quite a number of things. More Dominic, you say, or you are saying more. Dominic says watching from Japan. So much like this radio station, Odala and Kabun Kanye. All right, thank you so much for your comments. Clement Odife, good morning. Nnamdi Kanu had a written address. Why was the address not admitted or read? All right, the lawyer in the studio is just doing academic exercise. He can't stand mad. Nnamdi Kanu made so many valid points which were not considered. There is nothing anybody could have done because the issue was predetermined. All right, Elechi, okay, because that's Clement Odife. Elechi Benjamin Madabuchi says, a very good morning to you, Dr. Tony Lisambeki, and the barrister in the house. Your analysis this very morning are very clear, even to the deaf and dumb to hear and see. But my question is, does it mean that Mazen Nnamdi Kanu legal team are not in tune with all these lapses you pointed out, ranging from the loophole of failing to go to the appeal to stay the prosecution and not making case for the time of the sentence, or are there different kinds of law schools for different lawyers? Maybe the kind of law school you attended might not really be the one they attended. Secondly, as a human rights activist and someone who is concerned about his family and children, is there no role you can play in correcting these mistakes, barrister in the house? That's according to Elechi Benjamin Madabuchi. We also have Amadio Television who says, good morning, Tony. Please ask the IPOP or an ESN lawyer in the studio if they really want Igbo land to heal. Is he not aware of the damage, setback, loss of license Nnamdi Kanu and his IPOP cost Igbo, the family of Chike Akonyele, and many other people that lost their loved ones, including Tony Lisambeki, that have not traveled to his village Osumohu in 6 years, at least gotten justice? It should be that Tony Lisambeki has gotten justice but not have traveled to his village for 6 years. For him, it should be a death sentence. Let Alibo heal. No, there are so many comments. Ichen Nanyalugo Abagana. Ogaragli, please ask the council there with you if he want to die with his legal experiences. Why didn't he market his knowledge on Nnamdi Kanu's lawyers?
Okay.
Or is he just doing an academic exercise in the studio? As he speaks, I know that he knows how to speak and he knows what to do. However, his submissions are well taken note of. Let him find a way to speak to lawyers of Mazen Nnamdi Kanu while they proceed to appeal. They should consult him, and he should be their consultant as they move forward to appeal. I recall that during Iwoho, you said quite a lot of things I may not read out here. Dubemobu, good morning, gentlemen in the house. Honestly speaking, the barrister in the studio is so biased. That's what you said. That's all you end of. They didn't tell us how biased. So we have Ichie Billions, who says, good morning, Tony Lisambeki. Those hoping for presidential pardon for Mazen Nnamdi Kanu by Tinubu APC government should just think twice, because I do not see what it takes for Tinubu to consider presidential pardon on Nnamdi Kanu. Igbos gave him 5% vote for Buhari's government twice. Buhari won twice. Igbos rejected Tinubu, gave him less than 5% vote. Tinubu won. Excuse me. So there are so many comments coming here. Let's quickly answer some of the questions we have here.
Let's thank you first. I want to thank the generality of our public who have been sending in comments. You're the reason why we come on here and we do this. I thank all of you. Those who went saying the lawyer in the studio, ESN lawyer and all that, I take that as a joke.
Oh, it's the Labero ESN lawyer.
So it's a joke. I take it as a joke, and I take it as an ironical comment.
Okay.
Prince Christopher Omo, as a person, I've never worked for IPOB, I've never worked for ESN. I'm a private lawyer from the face that was called to bat till today. Okay? So let's get that clear on record. So I take it as a joke. Then second, the issue of my not going to Nnamdi Kanu's legal team or going to give them the advice and coming here to say it. I want to explain something about legal practice. There's a rule against advertising in legal practice.
You don't advertise.
Lawyers don't advertise. So the public should get that straight. Number 3, as an Igbo man, professionally, I had written comments, legal opinion, and sent, like every other person sent, to the legal team when the matter had not gotten to this escalated stage. And in all my own comments, what I kept saying is the same thing I've been saying to you today. Explore alternative dispute resolution. Don't let this trial go to the end. And you don't force your professional colleague to take an advice in a matter in which you're not counsel. So all of us who are saying, please explore settlement, they refuse to take the advice. Here we are. So the public should understand that it's not when a lawyer writes a private letter to a colleague during a case, you come in public and say what you wrote. It's also prohibited by the rules of professional conduct. So I will never tell you what I wrote in those letters to them.
Okay.
Then let's go to the serious issues. The family, like I pointed out, have to take that decision on their own at a family meeting that they want to explore ADR. When they take it as a family, they take the step themselves. They write a letter of engagement to whoever is the lawyer they want to engage. It does not stop the legal team from doing their appeal.
Okay.
If they say they want to write Prince Christopher Omo to come and guide them on the ADR process, I will not say no. But until they show me a minute of family meeting where that decision was taken, with a letter signed by principal family members, I will not accept. That is what is in the rules of professional conduct. You don't come on radio and brief people orally on such a sensitive matter. Then on the issue of capacity of Nnamdi Kanu to now say, no, this thing my family has done, I don't want it. Continue my appeal. If I die, I die. My stance remains the same. A man who is facing life imprisonment now lacks the capacity to take certain decisions. And one of the decisions he lacks the capacity is the capacity to say that his own blood relations should not ask for him to be forgiven. It is no longer in his hands. His relation should go and ask for it. Someone said it here. So these people do know this. If it's even their children, we don't know, go and get them out. Then we'll go to the next one. On the issue of ideological difference being what brought about the state of affairs today. This is the same thing I just use polite language to say. Multilateralism. How do you present your case? If the person who spoke had listened earlier, I gave an illustration with the case I did. Talking to different people with different results until I got to someone who got me that result. So if they want to engage the ADR, one of the things they must do is to go and look inside that judgment. Every ground to get Nnamdi Kanu a pardon is in that judgment.
That's the loopholes you mentioned. You
It
say
is
that
there,
the judgment
plenty.
contains a lot of loopholes.
Enough, not loophole, enough points.
But somebody said that that I have gotten justice. At least I've not traveled to my village for 6 years. That
that's
I've
the
got
point.
justice.
That's
and
the
that
point.
Tika Nkunyele has also got justice. Somebody wrote it.
Yes. In language, remember, there's a musician called Shina Peters. He did a song, Grammar, 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 no be my language, Grammar, Grammar. Grammar, the English language, is not the language of an Igbo man. It is a second language that we learned. The owner of the language has what they call irony in the English language. So that writer was using an irony. What he's saying, if you turn the irony, is that Dr. Lisa Mbeki, that Nnamdi Kanu has been sentenced to life imprisonment, will he make you have access to your home in Osumuhu? Answer, no. That family, the sentencing of Nnamdi Kanu to life imprisonment, will he make Dr. Chike Akunyele to come back from the dead? Answer, no. That is the irony.
But the people are saying that he created monsters. Because of time, he created monsters. And these monsters festered all over the southeast. And this could be a kind of justice for the monsters he created that haunted Alibo.
The same monsters Gaddafi was accused of creating until Gaddafi was killed and Libya became a failed state. Ndi Igbo should not allow their home to become a failed state or a failed region of Nigeria. That is why I said, please, whatever we do, put the judgment on the table, find legal grounds in it to do what? To bring Mazin Nnamdi Kanu and send him to go and live with his children.
All right. We have a statement coming from the Minister of State, Bianca Odumegwu Ojukwu, where she said, and she pointed out that she would like to reassure Igbo Nigerians and our foreign partners that there are still prospects of resolving this in pace in a manner that reduces national anxiety and societal trauma. And she went on to say, I oblige everyone to remain calm and patient. Over the years, I have continued to engage on these issues with several stakeholders. Now is the time for us all in Alibo to put all our hands on deck and just have a joint engagement, sincerely involving all the southeastern states to seek a political resolution to this matter. Minister of State, Foreign Affairs, Bianca Ojoko.
So we're back. So what I said here on the studio was not academic exercise. That even the Minister
of State for Foreign Affairs
have seen the same thing I saw, that use the political option and end the impasse.
And she's always close to Mr. President. Both of them talk from time to time.
And then she should reduce
but
some
she
of these
said
things to
joint engagement, but you are saying different engagements. But she said joint engagement, but you said different engagements.
Speaking from political perspective.
Oh, political joint engagement.
Political joint engagement.
Not the one involving the family.
No. The family should stay away from that thing. Okay. That's my professional advice.
All right.
Because that is for politicians to be doing. Let them be doing it from the left. The family should stand in the center.
We are completely.
Then the lawyers should go for the left and do legal representation.
All right, thank you so much. A final statement, Barrister Christopher Moore.
My final statement is that in all we do, the Igbo ethnic group should come together and do their best to de-escalate the outcome or the fallout of the life sentence imposed on Nnamdi Kanu, so it does not derail Igbo land for the next 20 years.
All right, thank you so much. On that note, we have come to the end of this wonderful engagement on Crossfire on Udala 104.7 FM. We still have comments on our social media, and we are going to look at those comments. You can still pour these comments there. These comments are not going to be invalid. We're going to just look at them and possibly bring them back during our time on Polity on Monday. Thank you so much, Barrister Christopher Moore.
Thank you.
A human rights activist, a constitutional lawyer, and also an advocate of the Supreme Court. Thank you so much for your time.
Thank you, Dr. Lisambeki.
Thank you so much, our listeners, and those who joined us from Japan, from Mexico, from South Africa, from Ghana, from Kenya. Irrespective of where you join us from, we appreciate all of you. And we have to really adjourn at this point until we reconvene on Monday on Polity. Do have a wonderful weekend. My name is Dr. Tony Olisambeki. Bye for now.